the designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast local governments need to do business. In the chair, it's me, Katie Nagy. On the agenda today, it's Title II of the Americans with Disabilities Act new rule, Web Content Accessibility Guidelines. But first, let's call the roll. Joining me today to discuss this topic is Jamie Wilkie, a partner at Lauterbach and Amen. With over 2 decades of experience in the government sector, Jamie leads an accomplished career in the public finance industry. Her expertise and clients extend to municipalities, park districts, school districts, libraries, special districts, and various other governmental units. Thank you for joining us today, Jamie. Jamie Wilkie is here.
Present. Thank you for having me, Katie.
So, Jamie, as this episode is all about web content and mobile applications, what is your most frequently used website or app?
Well, I had to chuckle because as a mom of 3 teenagers that are obsessed with sports, my common app is actually TeamSnap. So it is an app that tracks all of the kids' schedules, chats with coaches, communication about uniforms, locations, etc. So I am typically on there multiple times a day.
I admittedly am not familiar with that application. My dog doesn't require as much scheduling and communication.
Yeah.
Mine, I hate to say it, probably Amazon.
Okay.
I need to delete it off of my phone. Every other day I'm getting a picture frame ordered or paper plates. Yeah. It's becoming a problem.
I'm a culprit too, so bear with you.
We're in good company then. And behind the glass for our protection, engineer Rick is present. And we have a quorum. Dear listener, today's discussion with Jamie is all about the Department of Justice's final rule updating regulations of Title II of the Americans with Disabilities Act and the rules requirements for state and local governments to ensure that their web content and mobile applications or apps are accessible to people with disabilities. We'll walk you through the legal and regulatory background of the ADA, its digital scope, applicable technical standards, and compliance guidelines. Jamie, what should our listeners expect to learn today?
Well, first of all, I want to thank you for having me today on the show. Really important topic, really timely topic, I think, as we talk about due dates. So we'll touch base on a variety of ADA topics, including some practical steps for client policies and implementation, document accessibility, exceptions to the rule, and we'll learn more about those, and certainly some risks for non-compliance. After listening to the episode, we hope that listeners should understand what the new digital accessibility mandate is, along with some of those more practical steps for each entity to be taking to ensure compliance.
It's going to be a great episode, listeners. So, Jamie, before we jump into the technical components of the discussion, can you please share with the Quorum Forum listeners why accessibility is so important for local governments?
Great question. I always chuckle that local governments live in a world of transparency, the T word, right? So to put it simply, good accessibility is really good government these days. It really does lead to better service, a broader reach for content, improved trust, certainly fewer complaints, hopefully from residents. And on this topic, really accessibility is not just something that's nice to have. This is required by law. So it's also one of those we can't get out of it. So with services also becoming really increasingly digital, whether that be online forms, online payment systems, mobile apps, it's really important to ensure that these services are accessible to those folks with disabilities. So aside from principles of good governance, really ensuring compliance also avoids any legal or reputational risks for our public entities out there.
definitely important. The more that local governments can get their services and programs out to a broader audience, that's always a great thing. As well as you pointed out, if you can get fewer complaints from residents, I don't think any local government would not want that.
Exactly.
So, listeners, as you may already know, Title II of the ADA requires state and local governments to ensure that their services, programs, and activities are accessible to individuals with disabilities. In April 2024, the DOJ published a final rule to include specific technical standards for state and local governments' web content and mobile apps to ensure that local governments' web content is accessible to individuals with disabilities. Jamie, could you please go over for our listeners some of these technical standards, or what the technical standard is?
Sure, absolutely. So the Web Content Accessibility Guidelines mandate, that's a mouthful, so bear with us, mandates that state and local governments ensure that their web content and mobile applications meet WCAG 2.1 Level AA as the technical standard. Quite the acronym. We'll obviously spend some more time breaking that down, but I do want to note that that is really the technical standard that we're covering today. There is a little side note to that. Local governments may also use designs, methods, or techniques as alternatives to WCAG 2.1 Level AA. If that state or local government can prove that that alternative provides the same or more accessibility or usability. So that specific piece really refers to equivalent facilitation. The rule itself also applies to any web content or mobile app provided by or made available by state or local governments. And of course, we'll be digging in further to those details.
Thank you, Jamie. I think it's important to note for our listeners, too, as we'll get into the compliance deadlines for the accessibility guidelines, that it's the DOJ's position that accessible web content is not necessarily a new obligation for local governments. The DOJ is clear in the published final rule that the non-discrimination requirements under the ADA should already apply to all government services, including their web content. So it's the DOJ's position that this new rule is not creating a new obligation. Rather, it's establishing technical standards for web content and mobile app accessibility in order to give public entities greater clarity in how they can meet their ADA obligations. Now, the ADA rule provides a lengthy and wordy definition of web content. To put it simply for our listeners, web content is any content that public entities provide or make available to the public that is accessed by a web browser. Jamie, can you give our listeners some examples of the types of web content that local governments will likely have to review in order to ensure their web content complies with the ADA guidelines?
Absolutely, and I think as you indicated, wordy is a great descriptor of what the web content definition looks like within the rule. So I think more from a practical standpoint for most state and local governments, web content in the rule really does apply to more than just thinking about your website in general. It covers any digital services, things like forms, maps, dashboards, and even documents that you post online. So in the local government context, many of our clients have also social media platforms, online newsletters, community portals, or even online payment portals. Posted documents may include things like meeting minutes. I know your firm provides lots of those.
Oh, yes.
As far as input there, agendas and videos, and a little plug for our industry, maybe even your audit document would be posted out there. So all of these would be considered web content and certainly fall within the scope of the rules.
There's definitely a large variety of the type of web content local governments provide now. Like you pointed out, a lot of units of local government don't just have a website. They'll have a YouTube channel, a
Right.
Facebook channel. So, Facebook channel.
Yeah.
I don't know what that is. Maybe that's a new app we can create, a Facebook page. But yeah, so it's not just likely as simple as just looking at their website. They have to look at all of these different forms of web content. So I think it'd be helpful to go over some of the background on the Web Content Accessibility Guidelines 2.1 Level AA Technical Standard. Jamie, could you share some of that background with our listeners?
Sure. So that big mouthful you just said. So WCAG 2.1, as we refer to it, really is the benchmark then for accessibility compliance. So that kind of needs to be the rule of thumb that folks are following. That is developed by the World Wide Web Consortium, W3C.
A lot of acronyms.
We love our acronyms, right? And really sets the criteria for accessibility, which really refers to being perceivable, operable, understandable, and robust. So that's kind of the general framework. Level AA in particular means meeting all of Level A and AA success criteria. That specifically includes things like keyboard navigation, color contrasting, alternative text for any images, and captions for videos. Certainly not an all-inclusive list, but those would be common examples. Some entities may go beyond this level with a higher level or more advanced criteria being applied, but meeting the rules really is required at that level AA kind of standpoint. Common issues we see in meeting that rule, I'll be honest, missing alternative text. So you might have documents that have charts or graphs and we're missing that kind of narrative. Insufficient color contrast could also be a common issue. Forms that aren't keyboard accessible, PDF documents that aren't properly tagged, or maybe lack of captions on video. So again, just some common examples we're already seeing as we work through implementation.
And I actually have looked at the WCAG 2.1 Level AA standards, and it is very technical for our listeners that haven't looked at it. It is very specific and very technical.
Yes.
So, as we'll get into a little bit, it might be helpful to bring some outside help or consultant because
absolutely,
a lot of it did not make sense to me, like the specific image ratios that went above my head for sure.
Yes.
So, listeners, you're probably wondering, well, when do we have to comply with the new accessibility guidelines? Jamie, when is the compliance deadline for local governments to comply with the new standards?
Great question. It's quickly approaching, we'll just say that. So government entities with a population of 50,000 or more must comply by April 24th, 2026. So we're really just a few months away from that first kind of tranche of implementation. For government entities with fewer than 50,000 people and for special districts, the deadline is April 26th, 2027. Very random in the middle of the month dates, but so be cautious with that. And I know, Katie, you'll be covering a little bit more on the special district definition coming up here. So we'll certainly help define that a little better. It's important to note that after that initial deadline, this requirement really doesn't go away. It is ongoing. So we do recommend that entities start to take compliance measures as early as possible. Hopefully you've already had some conversations internally if you're one of those over 50,000 populations. But really we need to make sure that we take the time to audit, remediate, update policies. You really don't want to have your back up against the wall from a timing perspective on this.
That's a great tip, Jamie. Thank you. So I know many communities have inquired about what is a special district government under the ADA accessibility guidelines. Now, listeners, we recommend that you reach out to your attorney to determine the specific compliance deadline for your unit of local government. However, I want to note that there is well-founded confusion on what a special district government is under the ADA rule. The ADA rule, and this is a little bit lengthy, so stick with me, listeners. The ADA rule defines special district governments as a public entity other than a county, municipality, township, or independent school district authorized by state law to provide one function or a limited number of designated functions with sufficient administrative and fiscal autonomy to qualify as a separate government, and whose population is not calculated by the United States Census Bureau in the most recent census or small area income and poverty estimates. So the ADA rule really is intertwined with the U.S. Census Bureau. The ADA rule guidance provides that their definition of special district governments is drawn from the Census Bureau's definition of special district governments, as well as I just stated, the populations for compliance deadlines are based on the census population reports. So, for example, Illinois law may categorize local libraries as a special district government, but the ADA rule guidance notes that you can look at the population of the larger government that they are a part of. So in this example, the library is an instrumentality of a city, so the local library can determine its population based on the city's population. Therefore, a local library may not constitute as a special district government under the rule. The ADA does have a hotline for you to call into and ask questions, so I definitely recommend you either reach out to your attorney for guidance or reach out to that ADA hotline. Our listeners should hopefully have a good picture of the rule's background and its scope. Jamie, what are some practical steps and policies that our listeners should take to implement accessibility?
Great question, Katie. I think the first response relates to accountability. So first step is really identifying a person or team internally that is going to be responsible for this digital accessibility project. Whether it's someone in IT, maybe your entity does have an ADA coordinator, or maybe it's a small team of folks who might, be responsible for web content. It really is important to identify those folks, define roles and some responsibilities. And I think you noted before, I have seen clients who are utilizing outside consulting experts to be part of that implementation team as well and ongoing monitoring. So certainly something to consider. It's a lot to digest in the requirements. Really from there, we need to take a step back and conduct an inventory. So as an accountant, I have appreciation for inventory counts, but we really need to identify what are all of those digital assets. So it's really important, again, to be aware of not just your website, but any mobile apps, what documents are posted on the website, any online services that the public might have access to. Then finally, it's really audit time. So again, I'm putting on my auditor hat. We need to look at those items we've identified within that inventory and really decide, how are we going to assess whether it meets the criteria or not. That can include both automated scanning or human testing. So either it's a manual process or we might be using some technology to assist. For example, I know many folks use Adobe, and there are certain versions of Adobe that you can actually utilize a tool to scan for ADA compliance. So that may be a useful tool for folks. You need to go through your digital assets and identify any potential issues. That's really the goal through this process. And once those issues arise, I think it's really important to prioritize remediation of those high value, highly used content. So it may be a case where we can't do everything on day one, but we should really focus on those high value, high usage content items.
Thank you, Jamie. Those are some great tips. Listeners, can you believe you're getting this for free? It's a great deal. So, Jamie, you noted previously that the accessibility guidelines are an ongoing requirement. It's not just a one and done project. So what can our listeners do to ensure that compliance continues beyond just being a one-time project?
Sure. Yeah, I think unfortunately, with a lot of the more recent mandates, it's not just doing it once, it's building a process internally then to continue that monitoring. So we really do need to ensure that those accessibility checks are part of any ongoing process. From a practical standpoint, vendor contracts you may want to take a look at to make sure any vendors that you utilize that are delivering website apps, documents that you're putting out there, they really should be providing that in an environment that meets those accessibility requirements. Again, specifically outlining in any RFP or contracting that WCAG 2.1 level AA criteria will in fact be followed by that vendor. Any content updates, new web pages, any new PDF uploads, or other digital content should be part of that workflow process. There should also be monitoring and reporting in place, so some kind of system for reviewing and tracking issues to ensure that the compliance process is smoother and we've identified any of those issues. Training is probably a giant piece of this. We both have mentioned kind of the detail that has gone into this new rule. You've got to untangle it first, and then really it's training any of your folks that might be involved with web content or document uploads, making sure they're aware of the standards and how to comply with them. I'd also encourage organizations to just be transparent. There's that big T word again, right? Post an accessibility statement. Identify that you're making that effort towards accessibility. Provide a clear way for folks to be able to reach out if they have issues. And really, I think that shows that good faith effort towards building trust and working towards those requirements within the new rule.
Definitely. Thank you, Jamie. So I know a lot of local governments are a little overwhelmed with the amount of documents they may have on their web content, specifically their website. You mentioned previously local governments upload their meeting minutes, agendas, etc., etc.
Yes.
There can be a lot of documents. So do you have practical guidance for our listeners to help them ensure that the documents within their websites are accessible?
Absolutely. So I think the most common form of documents we do see is probably PDFs. I think that's kind of become the rule of thumb these days. And so really that kind of group of documents becomes a strategic focus in all of this. So again, meeting minutes, agendas, PDF forms. A lot of clients have fillable forms, for example, on their website. These must be accessible if they fall within the rule. So now, what does that mean exactly? In practical terms, accessibility means documents need to be tagged correctly for screen readers. Again, we talked about containing text alternatives for any graphics, be keyboard accessible, and not rely solely on colors. So I recommend that any new documents you're creating, please keep accessibility in mind. So those key items we just talked about as you're creating new documents to post, make sure that we're addressing that up front instead of trying to retrofit kind of the old versions, if that makes sense. It's best to provide templates as you're able to and train, again, those staff that are involved in that workflow of posting documents. When a form or document is updated, again, I can't stress enough that accessibility concept has to be part of that process.
So Jamie, you mentioned that new documents should be created with accessibility in mind. What about documents that are pre-existing and are already on a local government's website? Do those pre-existing documents need to comply with the accessibility guidelines?
Great question, and probably a common one I know our office has been receiving. There are a few exceptions concerning pre-existing documents. So for example, conventional electronic documents, which are PDFs, probably most common, word processor files, that one I feel old saying word processor, presentation files, spreadsheet files, etc. Anything like that is part of your government's web content before the date the local government is required to comply with Title II ADA rule are exempt from compliance. And I'm going to pause here because we have to keep going.
Caveat, yeah.
But unless such documents are currently used to apply for, gain access to, or participate in any services, programs, or activities delivered by the government. So if they're still being used, we need to clarify.
Yep, and that was a perfect timing for the pause. It is a big caveat to that exception. An example for our listeners of when this exception would and would not apply If a local government posts a PDF version of its business license application on its website in 2020, but members of the public still need to use that PDF to apply for a business license after the local government's compliance deadline, the exception would not apply to the application, and generally it would need to meet the accessibility guideline technical standards because it falls under that caveat of it's used to apply for services, programs, or activities. In contrast, if a local government website contains a series of out-of-date PDF reports on local COVID-19 statistics, those reports generally would not need to conform to the technical standards because they're not being utilized by the public, again, to apply for, gain access to, or participate in services, programs, or activities. So it might be a fact-specific analysis of looking at each document to determine whether it would fall within that exception.
Absolutely.
There are other exceptions as well under the rule. Jamie, what is the most common exception that you are seeing your clients inquire about?
That's an easy answer. The exception related to archived web content. So I would love to hear more from you, Katie, on that interpretation.
I can definitely help with that. So archived web content, in order for that to be exempt from complying with the technical standards, the web content must meet the 4 following requirements. First, the web content must be created before the compliance deadline for the local government, or the web content must reproduce paper documents or physical media that was created before the compliance deadline. Second, the web content must be retained exclusively for reference, research, or record keeping. 3, it cannot be altered or updated after it is archived. And 4, it must be organized and stored in a dedicated area clearly identified as being archived. The rules guidance is clear that this is not supposed to be a get out of compliance like exception. You can't just put all of your web content documents in an archive. That would not be complying with the ADA rule. So what likely will be the relevant inquiry under that exception is whether the web content is retained exclusively for reference, research, or record keeping. Somewhat similar to the exception we just talked about of pre-existing conventional documents. Absolutely. If a document is used currently for the public to get information on the local government, to participate in a program, you can't just put that in an archive and say, okay, we archived that document, doesn't need to comply. So again, it probably will require a close look at your documents to see whether or not it's being exclusively retained for reference, research, or record keeping. Yeah, I actually am surprised at the amount of units of local government I'm seeing on Facebook nowadays. Talk about unhappy residents. So, under the ADA, any social media posts posted by local governments before their compliance deadline are not required to comply with the Web Content Accessibility Guideline technical standards. Many communities post their public meeting videos on YouTube. If the meeting videos are posted prior to their compliance deadline, then those videos would not need to comply. Of course, there's nothing prohibiting local government from complying with the guidelines, but technically under the rule, those pre-existing social media posts would be an exception to the rule. So Jamie, you also noted the importance of reviewing vendor contracts related to web content. Content posted by a third party is exempt from complying with the accessibility guidelines unless the third party is posting due to contractual, licensing, or other arrangements with the public entity. So, for example, a message board where residents can post on a municipality's website, that message board and the content within it would likely not need to comply with the guidelines. In contrast, as you noted, many local governments post content on their website that is developed by an outside technology company, such as calendars, scheduling tools, maps, reservation systems, and payment systems. This content would not fall under the exception as a local government is contracting with this third party to provide the web content. So, as you noted, it's very important to have language in local government's contracts with these third parties and companies concerning the local government's obligations under the ADA. Jamie, would you please share the remaining exception under the ADA with our dear listeners?
Absolutely. The last exception that we'll be chatting about is really when there is an individualized, password protected, or otherwise secured conventional electronic document. Those specifically have to be documents about a specific individual, their property, or their account, and has to be password protected or somehow otherwise secured. So a great example, this might be a PDF version of a water bill for an individual's home that is available only through that individual's secure account on the city's website. And that would be a great example of something that might fall under that last exception.
Definitely. Thank you, Jamie. And it's important to note there, a PDF version of the water bill is important in that example because, as you noted previously, conventional documents are, for example, PDFs, spreadsheets, and word processors, which everyone uses. So, listeners, I just want to note, after talking about these exceptions, that these exceptions do not negate a local government's duty to provide individuals with disabilities with effective communication, reasonable modifications, and equal opportunity to participate in or benefit from the public entity's services, activities, and programs. So, for example, if an individual with sight loss requests access to a picture from a 2021 social media post from a city's Facebook page, regardless of the pre-existing social media post exception, the municipality is still required to meet its obligations under the ADA. So that would likely be a conversation with the individual seeking access to the photo and what the correct format would be for that individual. So if someone is requesting something that would fall under an exception, the proper answer is not, oh, sorry, that content doesn't need to comply, but thank you for reaching out. So keep in mind that duty is ongoing. So different than an exception and more of a limitation, the ADA rule provides that in meeting the accessibility requirements of the rule, a public entity is not required to take any action that would result in a fundamental alteration in the nature of a service, program, or activity, or an undue financial and administrative burdens. These limitations mirror the fundamental alteration and undue burdens compliance limitations that are currently already provided for in the Title II regulations. So local governments may be a little more familiar with these provisions. Jamie, could you explain to our listeners, please, how would a local government go about asserting a limitation such as fundamental alteration?
Great question. So that burden of proving that compliance with the web content accessibility guidelines would fundamentally alter the nature of maybe a service, a program, or activity, or potentially result in undue financial or administrative burdens really does rest with the public entity itself. So that decision that compliance would result in a fundamental alteration or impose that undue burden must be made by the head of the public entity or a designee, and must be clearly memorialized in a written statement with reasons supporting the conclusion of that limitation.
Definitely. So that likely is a fact-specific analysis that differs for each local government. So, Jamie, turning back to practical implementation for complying with the web content accessibility guidelines, Jamie, more free advice, not legal advice, listeners.
No, I'm not an attorney.
Yes, not legal advice on either of our parts, but what further tips can you provide our listeners?
Absolutely. So as we've kind of chatted about already, since many websites, apps, or documents are being developed or maybe managed by outside vendors, contracts with those vendors really should include going forward any accessibility language. Some other practical tips, I've got kind of 6 of them here that we'll walk through. First, procurement processes providing for the requirement to deliver WCAG 2.1 level AA, testing and certification clauses, documentation, periodic audits. Again, this relates to contracting terms, the procurement process, really making sure any folks involved in your entity's securing of contracts are really aware of this language to be added. Monitoring would be number 2. So we're kind of trying to get to this end goal of compliance. We have to know where we start, and hopefully we have some monitoring along the way. So the idea of setting up what we would call kind of KPIs. So what % of pages on your website have you remediated? What are the number of accessibility fixes kind of that have been logged? Do we have user feedback? So do we already have folks reaching out with some of that feedback? And then certainly making sure monitoring of new content that is posted out there, is really part of a policy and procedure. Number 3, reporting back to leadership. So because this is really a risk to the government itself, both management and your elected officials should be receiving status updates on where you're at with compliance. Number 4, and this is one I get a common question for because local government budgets are really important. So we need to consider some of that budget planning. This is not a simple process. So we need to consider from a budgetary perspective, what are remediation costs? What is ongoing monitoring? Who do we need to train and how? And really much of that may come back to internal staff time from a budget perspective or utilizing outside consultants or vendors. Number 5, consider using a feedback channel. Really important to provide users of your web content with a way to contact you if they have accessibility issues. So keep those lines of communication open. And lastly, documentation. Highly recommend that you maintain or develop an accessibility statement or policy directly on your website. Make sure we're transparent and we're showing good faith and a commitment to meeting the criteria.
Thank you, Jamie. Those are some great tips. And as you mentioned, there is risk with complying or not complying with the accessibility guidelines. And listeners, there are legal risks for local governments that do not comply with the new ADA rule. If an entity fails to provide accessible digital services, it may be exposed to complaints under the ADA, potentially lawsuits and enforcement by the DOJ if any of the web content is found to not be accessible in compliance with the rule. There's also a financial risk. The prevailing party of a lawsuit under Title II of the ADA is permitted to recoup reasonable attorney's fees, including litigation expenses and costs. So there is legal risk if local government's web content does not comply with the guidelines. Jamie, what other risks are there for public entities failing to comply with the accessibility guidelines?
Another great question, Katie. I always say in local government, you want to stay out of the newspaper,
yes.
Right? So the risks that I want to cover are more kind of reputational and operational in nature. First, from a reputational perspective, residents and stakeholders within the community or within the public entity really expect accessibility. So failing to do so may erode public trust, raise some concerns, you're dealing with maybe some complaints, right? Second, operational. So when we look at that, inaccessible services may exclude an entire segment of your community. So they may want to participate in some of those programs and services. And this can certainly lead to increased phone calls, manual processing, inefficiencies, and certainly higher costs to ensure compliance once those are identified.
Thank you, Jamie. It seems like in addition to legal risks, those reputational and operational risks go back to what you stated toward the beginning of this podcast about good accessibility is good government.
Absolutely.
So that's something to keep in mind, listeners. It's not just legal and financial risks. There are more risks at play with the public trust. Jamie, do you have any resources you could point our listeners to help them with complying with the new guidelines?
Absolutely. There is quite a bit out there on this. As we said, there's a lot to digest. So the U.S. Department of Justice has published a fact sheet on this new rule. You can find that on ada.gov under its Guidance and Resource Materials section. And specifically, that page on ada.gov, that Guidance and Resource Materials page, also provides tips for compliance. The guidance there is called First Steps Towards Complying with the Americans with Disabilities Act, Title II, Web and Mobile Application Accessibility Rule. Oh,
everything's wordy.
We either have wordy or acronyms.
Yes.
It's never anything in between. So again, ada.gov, Guidance and Resource Materials, great place to check out some additional guidance. There are also accessibility checker websites and accessibility checker technologies on some of the document platforms. I mentioned, I think, the Adobe, certain versions of Adobe, for example, have those checkers built in. However, I do want to caution, the website accessibility checkers are not perfect technology. So please don't let it just replace your review of your web content. And I do want to stress as well, compliance with these rules is not just an IT project. It's really cross-departmental and really needs to have some education. So IT may not know what type of documents typically get uploaded or be able to identify, for example, our archived documents. So really, I think the best approach is a team effort on this.
Well, Jamie, thank you so much for coming on to the Quorum Forum podcast. It's been a pleasure speaking with you today. As this is a regular meeting, we do have to have public comment. This week, we received a question from Joe, a resident in Illinois. Can my municipality pass an ordinance authorizing it to dispose of vehicles and enforcing its traffic code? Joe, thank you for writing into the Quorum Forum podcast. The Seventh Circuit recently touched on this issue in the case O'Donnell versus City of Chicago. In this case, the City of Chicago adopted an ordinance authorizing it to immobilize, tow, impound, and ultimately dispose of vehicles in enforcing its traffic code. The city exercised its authority under the ordinance and disposed of 2 vehicles. The vehicle owners subsequently sued the city, claiming that its forfeiture scheme was an unconstitutional taking under both the U.S. and Illinois constitutions. The district court dismissed the claims, which were then appealed to the Seventh Circuit Court of Appeals. The Seventh Circuit upheld the dismissal, finding that the city's forfeiture program, which included provisions for notice and a hearing, and included graduated penalties for multiple violations of the traffic code, was an exercise of the city's police power to enforce its traffic code, a punitive remedy that did not constitute a taking. We now turn to the Department of Public Works. Dear listeners, I want to inform you that the Illinois Township Attorneys Association is hosting its annual seminar on May 15th, 2026, at the Hanover Township Senior Center. This is a great resource for Illinois Township officials and employees, and Ansel Glink attorneys will be presenting at the seminar. As always, we also recommend that you keep an eye out for the Municipal Minute blog for updates and more information. Jamie, I can't thank you enough for joining us today on the Quorum Forum podcast. I'm sure our listeners appreciate it as well. Before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We do prefer good reviews. Please send us your questions and show ideas to podcasts@anselglink.com. And as always, you can find us online at quorumforum.anselglink.com. Can I get a motion to adjourn?
So moved.
Second? All in favor? The ayes have it. We'll see you next time on Ansel Glink's Quorum Forum podcast.